All right, well, welcome to the Great Trials Podcast. As always, I am the host, Steve Lowry, here with Yvonne Godfrey. And Yvonne, we are doing something a little different this time. What's going on?
We're live in front of people, which is really exciting.
See, and things like that happen.
Steve already ruined it. Podcast over.
Yeah.
But thank you all for being here. This is really exciting for us.
Yeah, and when they said we were going to do this, they talked about looking behind the curtain of how the podcast gets done, and I'm not sure that's a good thing because, what you can see is that we're disorganized and we keep lots of notes, and then we try and what we do is we get great guests, and our guests make up for all of our failings.
That's right. There's more sweatpants when it comes to the real podcast because no one can see it. But.
Right. And we are so excited to have today our guest, Lance Cooper, who is not only a very seasoned, very successful trial lawyer, but for today, he's an experimental guinea pig because we have never done this before. So Lance, thank you for coming on here, and thank you for being the first one to do this in front of a live audience.
Sure. Well, I've got to say that if I'd have known I was an experimental guinea pig, I would not have showed up today.
But, we made sure not to tell you that.
Yeah, exactly.
Well, Lance, I know everybody here in this room knows who you are, but I want to go ahead and introduce you to the podcast listeners so that they know who you are. Lance has been practicing in Georgia, in Cobb County, since 1989. He went to the University of California, Berkeley, grew up in California, and then came east to go to Emory Law School, and has not only handled just tons of really big cases, especially against product manufacturers, mostly car manufacturers, but has also been the past president of the Georgia Trial Lawyers Association, the past president of the Cobb County Trial Lawyers Association, has the recipient of the Stephen J. Sharp Public Service Award, and was nominee for the Trial Lawyer of the Year by Public Justice. The case that we're here to talk about today was really just a groundbreaking case, and it was really done just by the fantastic work of Lance and his team over at the Cooper firm. And I forgot, I always tell everybody where you can find him. If you want to look up Lance and read about him or his firm, you can look him up at thecooperfirm.com. But Lance, thank you so much for coming on to the show.
Thank you all for having me here.
So this case that we're talking about is the case called Melton versus General Motors, and it involved the tragic death of Brooke Melton, who is a 29-year-old pediatric nurse. I think this was her birthday, March 10th, 2010. She was driving to her boyfriend's house. It was a rainy night, and while she was driving her 2005 Chevy Cobalt, she hit a puddle, lost control, or hydroplaned, and went across the center line and hit another vehicle, a Ford Focus, head-on, was spun down into a creek alongside the road there, and unfortunately passed away there. And that case, and the case that we're going to be talking about, sounds like in my mind, just listening to those facts alone, sounds like a pretty difficult wrongful death case if she's your client. But what happened in that case is that the work that Lance and his firm did turned this into a recall of over 30 million cars. They uncovered about 124 deaths that were linked to this defect of GM, and ended up in more than $2.5 billion in penalties and settlements against GM for their conduct in this case. And so I'm going to have Lance tell most of the story, but just very quickly, what they learned was that the reason why she had lost control that night was not because she was driving too fast for conditions, which was what was written on the accident report, but because her ignition of her car had actually turned off, which caused her to lose steering power, caused her to lose electronic braking power, and caused her airbags to turn off. And so that's what caused her to go across the center line. And after Lance's work on this case, uncovered that GM had known about this ignition switch problem where their vehicles could get turned off because of either heavy keys or getting it bumped by your knee, or just very easily because the torque in turning it and holding it was too low. And so that's what happened in this case. And the story of how Lance and his team just stayed with this case is really quite amazing. We're going to get to it, but I mean, at one point, Lance was able to secure a settlement for $5 million for his client, which was a good settlement. But after he really uncovered what exactly had happened, had the bravery, the courage to go and, with his clients, Ken and Beth Mountain, rescind that settlement and go after GM again, fight through the motions, and then obviously was able to secure a much larger settlement, but also more importantly, to make sure that millions of these vehicles were looked at and that GM was held accountable. And we're going to talk about it. I know that you don't think GM was held accountable enough, but we're definitely going to talk about that. But Lance, I mean, one thing I was thinking about when I was reading this case, both you and I do a lot of product liability work, and when I heard the facts of this case, when you see a police report that says that the decedent, hydroplane, was driving too fast for conditions, crosses the center line, hits an oncoming car, I mean, that sounds like a pretty tough case. How did you all get past that?
Yeah, before I answer, let me start. I know, this happened over 5 years ago, and y'all have heard, I'm sure, at least a fair number of you, a lot about the GM ignition switch and the melting case. So I hope this podcast both is informative as to the case, but also for the cases y'all have now in your office, some ideas that we talk about today that you can use, whether it's a product case or not, use to help your clients and also obtaining justice. So that's kind of the big picture of what I wanted to say on the outset. I can say that Steve's right. When the case came in, those were basically the facts that were presented to me. But what you can't see that I saw was Ken and Beth Melton, and particularly Ken. Ken was adamant, my daughter's a safe driver. She was wearing her seatbelt. There had to have been something else that happened here. And I didn't, frankly, think there was anything at that point, looking at the police report and just understanding the basic accident investigation. But there was something about my experience with product cases and also just cases in general that, and the kind of people Ken and Beth were, it made me think, I'm going to take a look at this one. We're just not going to turn it down. And there was nothing magical about it. It was just, it is interesting. She did lose control. Now, we did think she may have hit a puddle. We had the engineers from Applied Technical Services go out to the scene, and they determined quickly it was not a water issue. So we knew it wasn't a standing water issue. And then we did what we always do. We spent a little money to secure the vehicle, and then just started down this road. And we'll probably talk about it a little bit more, but what I also want to say at the outset is it really was not amazing work. It was the work we do in all of our cases. There happened to be incredible facts that were uncovered, but the work we did was, and I've said this before, it was basic blocking and tackling. We did what we do in products cases. We secured the evidence. We began to hire people to investigate. We spent the time and money doing that. And then when we got into the litigation, it was just, all right, this is what we do. When they do this, we respond this way, we respond that way. And it ultimately got to the point where they were being held accountable to produce documents, and all of the evidence got out that ultimately got out. But it wasn't, and that's why I want to encourage all of you, and when I've spoken about this before, is just, is what I've learned from GTLA and from this group AIEG. It was nothing amazing about it other than the fact that just learning from other people how to handle a product liability case, and that's what we did here.
Yeah, well, we're definitely going to talk about the discovery battle that you had, because, and I know you say it's nothing extraordinary, and it is the work that we do when you have a products case, but I mean, the documents that were uncovered in this case were extraordinary, and it wasn't like GM just handed the documents to you. There was a lot of work involved there to get them. But I wanted to go back for 1 second, just have you explain, There were a few facts that you all learned fairly early on that didn't jive with somebody just losing control or just hydroplaning. What were some of those facts that made Brooke's case different from others?
Well, what was interesting was shortly after we met with Ken and Beth, they were getting her mail after she passed away, and they got a recall notice in the mail for her power steering on the Cobalt. And that's really what caused us to decide to file the lawsuit, because the power steering issue, although it really wasn't supposed to relate to somebody traveling highway speeds, it gave us an opportunity to say, hey, we want to look more into this, and the only way we could do that was to sue GM and the local dealer, which was critical because it kept us in state court. And begin down that road, and we hired an expert. Give credit to Cale Connolly. We called Cale and we're asking about experts to look at this type of case, and he put us in touch with Charlie Miller, this mechanic from Mississippi, who's the best expert I ever worked with. And he's not an engineer, and he's not a medical doctor. He's a mechanic from Mississippi. But he was, and unfortunately, Charlie passed away recently, really tragically. And Charlie really started to break it open, because he came to us and it's not the power steering. But he went back and going on the GM website, he said, you know, I found this technical service bulletin dating back to January of 2005 where they were having an issue with their car stalling. And it's not public record, it's just the mechanics find this. And he said, let's look into this. And that's what really started down the road. So the power steering issue became not an issue, but it allowed us to file a lawsuit. And then we began that discovery process and the vehicle inspection process to where Charlie's really the one that found the first smoking gun, and that was the technical service bulletin that essentially found that back in January of 2005, even before they sold the Cobalt to Brooke, they sold hers in August of 2005, they knew there was a problem. And they'd actually come up with, it wasn't a fix, but it was a Band-Aid to deal with the ignition torque problem, but they had kept it under wraps at that point for over 6 years, and that's what started us down the road of pursuing discovery about the ignition switch.
I read somewhere else that there were two other things that y'all found out pretty quickly. One, I think that when her car was found, the key was in the accessory position, meaning the off position, not in the on position, which was odd. And then the other thing was that the SDM download, or the black box download that was done, showed some odd data as well. What was the odd data that showed?
Yeah, well, actually, when we did the download is when we saw that the key was in the accessory position. And that's before Charlie knew about the bulletin. He said, this is strange. This is it. And of course, we deposed the first GM. We took 30B6 deposition of a GM representative about the black box information. And that person knew exactly what had happened, but proceeded for over 2 hours to basically prevaricate and dissemble and essentially give me no answers. Well, I don't know about that. You'll have to. And they knew at the time what had happened, what that accessory position meant. It meant that when this crash occurred, her key was in the accessory position. In other words, her engine wasn't running, and most of her lights in her vehicle were off. So they knew all that, but they were playing ignorant. And so we had to, and there were some other issues on there which showed 3 seconds before the crash. You all may know about the black box data. It basically identifies what's going on in the vehicle 5 seconds before the crash. In 3 seconds, the engine speed went from whatever it was to 0. And so Charlie, started putting the pieces of the puzzle together for us, and that was the forensic evidence, which again, it's product liability 101, but we realized if we're going to represent Ken and Beth, we need to spend a little, and we may end up eating the cost, but we need to spend the money to secure the evidence. In this case, if we didn't have the vehicle, we wouldn't have had any case, because we wouldn't have had that evidence that allowed us to continue to pursue the discovery that we did.
Well, speaking of the things that you don't always have in a products case, you also had, Brooke had taken her car in to be serviced. You had sort of a documented complaint about this problem right before her death.
Right. That's why the dealership came in. Ken, and that was another reason. There's 2 reasons Ken and Beth came in. One was they really thought something had happened with the vehicle that was wrong. But also, Ken had gone to the dealership with Brooke that weekend before, followed her to the dealership because she had a stalling incident in a subdivision. She called, said, Daddy, can you follow me? I want to take this into Thornton Chevrolet, which he followed her. And while there, they told her they fixed it. And one of the things they said to Brooke was, you need to get your gear shifter changed. And it was like $500. And Ken said, well, let's wait and get essentially a second opinion. Let's take it to someone else. Well, Brooke died a day later. And Ken, I began to realize at the outset, had this tremendous guilt, because he felt like he may have talked his daughter out of getting a service that she needed and that caused her death. And one of the wonderful moments in the case was when we found, when Mark Hood, we'll get a little ahead of ourselves here, but we basically discovered everything. We sat down with Ken and Beth and we said, we know what happened. And he started weeping. He just said, I knew it wasn't Brooke. And it gets me emotional, because it was just a profound moment of not only knowing we were going to hold GM accountable, but Ken having this profound sense of relief that he was not the cause of his daughter's death.
Yeah, and I did want to talk about the work that was done where you figured out the two different ignition switches, and we'll talk about that in a second. But, I think from anybody who does, I think, auto products cases understands this, but maybe not everybody understands that how important it really is to make sure you get that vehicle, get the product, make sure you do the black box download, because in this case, what I saw was that the speed dropped from 58 miles per hour to 0 in less than a second. And that's just impossible. And so that was one of the things that Charlie Miller pointed out, I think, was that there was just no way that the speed could drop like that. So something had happened with the vehicle, and that something turned out to be that the engine had turned off.
Correct.
So talk to us a little bit about how you ended up narrowing it in on the ignition switch, and then the story about how you found out that there were two different types of ignition switch, a change in it.
So Charlie found the technical service bulletin, and when he did that, our initial discovery to GM was all about the power steering recall. So we amended our discovery to hone in on the ignition switch, what they knew, when they knew it, other claims and lawsuits and complaints. And I think this is an important point to make, is this typical, and you all know this within almost all defendants. They get the discovery, 30 days later, can we get an extension? Can we get an extension? We gave them 2 or 3 extensions, and just basically were giving them the rope, because we could then go to the judge when we knew, because the technical service bulletin, we knew there were documents relating to this. They didn't just come up with this out of whole cloth. And so we allowed for the discovery extensions, and then finally filed the motion to compel, probably 4 or 5 months after our original discovery was sent out, because we were just being patient. And at the same time, we were doing work behind the scenes. And, we get the call from GM's counsel, why'd you file this motion? And he said, we've got some documents we're going to give you. Well, they gave us a bunch of innocuous, harmless documents to them. And then we kept pushing, and then the big next break in the case was we got a hearing date on the motion, and so I got a call from the counsel saying, we got some documents we've discovered, more documents, and they produced them on a flash drive or whatever they produced them on. I don't understand any of the technology, but Doreen Lundergan in my office does, and she's just an incredible paralegal. I mean, she's just, I can't say enough about Doreen Lundergan, and many of you all know her and how fantastic she is, but she just started digging through the documents. And I think that's another important practice pointer, is particularly in cases where you're trying to get at discovery, when you get it, review it, and review it in detail, because they produced maybe 5,000 documents, but there were about 50 that were called these PRTS reports, which are Problem Resolution Tracking System. And she came in, I'll never forget it, in my office there, and said, you're not going to believe what I found. And I look at it, and it's a document from the chief engineer for the Cobalt in 2004, where he experienced an engine shutoff because of the ignition switch, and they engaged in this full-blown investigation to where in the spring of 2005, they knew the problem was the ignition switch, but they say it's not an acceptable business decision to change that, meaning they didn't want to spend the money. And it was less than $1 a vehicle to change it. And in fact, they had already changed it with the technical service bulletin, where, I don't want to get into all the details, but they had put a Band-Aid on it that if they had put that in Brooke's car, her car wouldn't have stalled. And she would be alive today. So it goes to the point of, the persistence in discovery, and they produce these documents, and we then have this time frame between 2004 to 2009 where they had a number of these PRTS reports where they continued to have the problem, they continued to investigate it, and they continued to kick the can down the road and do nothing. And in the meantime, we're thinking to ourselves, there've got to be complaints or lawsuits out there. And so we get a call from GM's counsel, I'm sure you're going to withdraw your motion now because we've given you the documents. We say, no, what you have to do is withdraw your objections. And so, of course, if you withdraw your objections and say you've given us all the documents, there's not much we can do with that other than we'll take some depositions to figure out whether you're telling the truth or not, but we can't proceed with the motion. He said, we're not going to withdraw our objections. I said, we're going to go forward with the motion then. And the other reason we thought that was necessary was because all of the documents ended at 2010 at that point. Now, we're in 2013 at this point, and it's like the story just ended. And we're thinking that can't be the case. There needs to be more to this story. And so we just told them, we know you have more documents. And they said, no, we don't. And then I don't want to ramble on and on too much, but the next critical point was, instead of accepting the fact that there were no lawsuits, claims, or complaints, we called a gentleman up in the Northeast, Sean Kane, who does a lot of investigative work for a number of product liability lawyers around the country, and said, Sean, can you identify for us, go on the databases, any cobalts with these kinds of crashes? And he calls back about 2 weeks later and says, I got one. He said, Wisconsin, Amy Rademacher, I think was the driver, back in 2007, she lost control of her car, the cobalt crashed, the airbags didn't deploy, and she and her friend, who was the passenger, were killed. And he said, and in the report that I found online as part of the government database, the officer determined that it was because of the ignition switch, because he had looked in the mechanical background and determined that there was a technical service bulletin. So this police officer in this state had basically cracked the case in 2007, but GM had withheld that from us. And another important point there, and we talked about this yesterday, was the government knew about this. GM and the government met about this. And GM basically bamboozled them into thinking, well, this really isn't a problem you need to look into. And so the federal government, whose job it is to protect us, basically didn't do anything about it. And so this Rademacher case was not given to us by GM. It was due to, and again, I just happen to know that we call Sean on almost every case. So it's not like it was any amazing work, but Sean did the amazing work to dig in and find this. So I called the GM lawyer up and shot straight with him. I said, listen, I don't want to play games with you. I said, there's a lawsuit here, and you all know about this. I can see you know about it. And he says, well, I'm sure GM did know about it, but I'll look into it. And then he calls back and says, well, they really didn't know about it. And that's, there's no more to it. You need to withdraw your motion. Anyway, at that point in time, we were basically full speed ahead to our motion to compel hearing.
Just as a practice pointer, because I think whether you do products work or not, we all get in these discoveries fights. You always get these boilerplate objections that are overly broad. You think you're not getting something, or they tell you you've got everything, but they're not going to remove their objections. As you were, I guess two questions. As you were approaching, knowing that you were going to have to follow through with this motion to compel in the hearing, I guess number one, how did you manage the documents that you did have? Were you doing it the old-fashioned way, just kind of looking at each document, or were you using kind of a service, an electronic type thing? And then number two, how did you approach everything as you were going to the motion to compel to make sure that the judge knew that you needed to be there, that this wasn't a petty thing, that you had tried to work this out, and that this was something you needed the court's assistance with? Right,
so yeah, we did it the old-fashioned way, and I wouldn't know how to do it any other way at this point, but we're trying to learn. And as far as it gets back to the point of the motion to compel, and that is, we just kept telling them, and I think this is important because as long as they continue to assert objections, it continues to give them an out with the judge at some, well, Your Honor, we objected to that if something comes up down the road. And so our position was, we don't know if you've given us everything because you've got objections out there. And the other important point is a lot of times we send this boilerplate discovery, and what you need to realize is if I'm going to go before the judge and say, their objection is without merit, I need to have a bulletproof request. It can't be all documents use every, blah, 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 blah. It needs to be, this is what we're asking for. This is what they've objected to. They're objections without merit. You need to overrule the objection and compel them to produce the documents. And if you don't have a tight request or a tight interrogatory, it makes it more difficult. So I think that's an important point. And they kept, what was interesting is they kept dribbling stuff out. So 3 days before the hearing, it was on a Monday, I get a call from the counsel, and he says, you know what? We found more documents. And he says, he said, and this is exactly what he said. They're not discoverable based on your requests, but our engineer looked at them when he was preparing for his 30B6 deposition, so we feel like it's necessary to provide those to you. And I said, I don't care, just give us the documents. And he said, well, we can't get them to you by Monday, but if you withdraw your hearing notice, we'll get them to you next week. And I said, no, that's not going to happen. We're not going to withdraw a hearing notice. And so, but what came from that was the 2010 to 2013, they had an ongoing Cobalt airbag non-deployment investigation going on the entire time our litigation was going on. And they, for over a year, refused to acknowledge they even knew about the ignition switch or any issue with the ignition switch. So we showed up at the hearing in front of Judge Tanksley. I know we talked about this before. And the one thing that's obviously critical in discovery is to have a judge that's willing to dig in. And Judge Tanksley was willing to dig in, and we talked about it. She's since retired, but she was no nonsense on both sides. If you as a plaintiff weren't shooting straight with her, she was going to call you out, and as the defendant it was the same. And the hearing was interesting because we went there, and their position essentially was we've given them everything, but their point was, we were talking about this before, they framed it in, we've conducted searches according to our search terms, and we've given them all the documents that we could find based on our search terms. And my point immediately was, and Judge Tanksley picked up on this, is, well, I mean, your production is only as good as it's garbage in, garbage out. If you don't put the right search terms in, who knows what you're giving them? And she just said, I just give them what, and we asked for it. I said, I don't care what the search terms are. I just want the documents we've asked for. And she agreed with that essentially, and ordered them to. And she was very. If I recall the transcript, I read it more recently. She was very perplexed by GM's position that there were no lawsuits, claims, or complaints, because they were still taking the position at that time there were no lawsuits, claims, or complaints. And she was perplexed at that, and she ordered them to produce documents, and ultimately what came from that was dozens of fatalities that they had more or less attributed to the ignition switch, although the documents weren't real clear, but the testimony subsequently became clear.
Yeah, and I think one thing to point out about that in reading your transcript, Lance, was that I think the reason why she was so perplexed with the fact they were saying there was no claims, lawsuits, or complaints is because you, through other third parties, through government databases, through talking to other lawyers, through talking to people like Sean Kane, had actually found some on your own.
Right.
And were able to show that to her, and then she said, well, obviously Mr. Cooper could go out and find these. GM, why are you saying there's none here?
Right.
And that's that step in the work of far as the discovery of going out and not just accepting what the defense says, but looking in other sources, as many as you can, to gather up other claims, really, in my mind, turned the judge in that case where she didn't believe what GM was saying.
Yeah, I agree. And I think, and it goes for every case. I mean, to identify third-party sources or other experts or other independent consultants to really, because a lot of these cases, not just products cases, or the defense has a lot of the evidence you need, and to simply rely on them to be truthful and candid and giving you the information is short-sighted. And we try to, in all of our cases, identify what are the other sources where we can gather in evidence to make sure we got everything we need to represent our client.
Right. Well, especially when they play that game that I hate, when you have like a 6.4 call and they're like, oh, just give us some search terms. Give us your search terms and we'll search those. And it's like, no, I don't know what you call this stuff. I don't know what abbreviations and what terms you use. I don't want to give you the search terms and then you run your search and you don't find everything. But it's making that clear, and it's having a judge who will dig in and get that it's a game.
Yeah, and I'll give a shout out to Drew Ashby. Drew really enlightened me as to the importance of e-discovery, and I think it is important to have e-discovery protocols and identify e-discovery that you can obtain from the defendant. But I have noticed at the same time that defendants are trying to use that to say, well, we're all good with e-discovery. You give us, we'll agree on search terms, and then we'll produce documents according to those search terms. And my thought to that is, I go back to Judge Tanksley, and that is, I don't know if it's garbage in, garbage out. I'm not sure what I'm getting. And so I feel as though, and we've done this in the more recent cases, is just give us the documents that we've asked for. And it's not onerous, it's just whatever, and if it's too onerous, then convince the judge it's too onerous. But I think when you do this cat and mouse back and forth, you may be constraining the evidence or limiting the evidence that you may be entitled to and may be there because they've been able to convince you, hey, we're going to search these particular columns of evidence where there may be a lot more.
I wanted to go back to something, one of the things that we haven't talked much about is that in this case you learned, and it took a lot of work, but you learned that there was a change in the ignition switch that actually fixed the ignition switch. And if I read it right, the way you learned that was that you had the 2005 ignition switch, and that was fairly easy to turn off accidentally. And then Charlie Miller, your expert, had purchased a new ignition switch which had the exact same part number. So GM was saying these are exactly the same, but when he tested them, they weren't exactly the same.
Well, there's actually, it's almost like that.
Right.
But,
a lot of times I get things just happen.
No. But what happened is Charlie said, I'm a mechanic, you need an engineer. And I had some engineers in mind, but he recommended Dr. Richard McSwain out of Pensacola. He'd worked with him a lot. I said, I had not worked with Dr. McSwain, but I knew him by reputation, so I said, fine. So I called Doreen called Dr. McSwain on my behalf. And in the point at which Dr. McSwain says he now regrets, he was too busy at the time, so he had Mark Hood in our office provide the engineering services, which was providential for us because Mark was fantastic. And so I got to Mark, but basically through Charlie. And Mark was the engineer who began to just investigate the case. But what Mark did was, and again, it wasn't anything that we did, we just hired an expert. He wanted to basically take apart the switch and see how it worked. So he went out to the local Napa, or had someone go out to the Napa Auto Parts store and buy a couple of new Cobalt switches, where you can replace them now. And I didn't know he was doing this. But he just was trying to figure out, how the switch worked. And he called, and I remember he called, and within a first sentence or two said, Lance, I figured out what happened. They changed the switch. And what he had done was he had taken apart a new switch and realized, and we don't have any of the evidence here, but they basically, there's a spring that holds the key into place, whether it's run, accessory, or off. And if the longer the spring, the harder it is to turn, is basically how it works, and they changed it. And I flew down with Mark and Charlie that day, because we did, or shortly thereafter, and we did a joint inspection with GM's engineers and experts, and essentially showed them, not the measurements, but showed them the difference in torque values between the new and the old. And GM was sort of nonplussed by that and really was not that concerned. But we obviously knew we had another smoking gun as far as the evidence is concerned. And we didn't know at the time all the details. All we knew is the switch had been changed. And Mark had discovered that. And that changed the entire future of the litigation, including the recalls and everything else, because it showed that GM not only knew about it, but had come up with a fix, but it chose not to tell the public about it.
Yeah, and so I wanted to get you to talk about this engineer that you had the opportunity to depose, who became infamous after this case, a guy named Ray DiGiorgio. He was the engineer who was the head of this group, and you deposed him about whether or not he had changed the design, and What did he tell you in his deposition?
A little backstory, and I hope I'm not going on
Yeah,
too
no,
long.
do whatever you want.
And y'all tell me when we need to start wrapping it up. A little backstory on that, because this is, again, it's sort of another practice pointer, and that is, when we realized the switch had been changed, we didn't tell GM, of course, as far as we didn't produce that information to them. We were trying to figure out what to do with that. And I had Mr. DiGiorgio's deposition scheduled within the next week or two. And I knew I was going to have to question him about this because he was the lead engineer. So we called GM's local counsel and said, and legitimately so, we need to take the depositions of these additional engineers before we put our expert up, because we need to make sure. I don't want to have to put him up twice if they testify to things he may rely upon. And they agreed. They really didn't think much of it. But that was critical, because if Mark had talked about it in his deposition before these engineers had been deposed, they would have been able to sort of concoct whatever story they would have concocted. And so we had DiGiorgio in a deposition, and we went through the typical scenario with him. And another important point, I think, in all cases is the 30B6 depositions are important, to take the depositions of the corporate representatives. But when you get to the engineers, or in medical malpractice cases, the nurses, or whatever case it might be, the local security people in negligent security cases, the people who aren't used to testifying, that understand, that take seriously the idea that they're sworn to tell the truth, and they're not expert testifiers, and you get much clearer answers. And with DiGiorgio, he was not an expert testifier. And when we put the old switch in front of him and pictures of the new switch, he was dumbfounded. At least he acted dumbfounded, but you could tell he knew. He was looking at GM's counsel. We put both pictures in front of him and said, "You changed the switch, didn't you?" I didn't know anything about that. I know nothing about anything. And we called him the Sergeant Schultz of GM. And but it really was devastating for them, because we had their lead design engineer essentially committing perjury. And we subsequently discovered that. So that's how we used that at trial. At deposition, and we had the visuals up, and it was real simple. I didn't have a lot of technology. I just had an 8.5 by 11 of the one switch and the other switch, and it was pretty clear that they had changed it. And he sunk himself a number of times in that deposition by denying that they had changed it. And that ultimately ended up being the another important point, and I think you take seriously errata sheets is, GM's lawyers knew that he had not told the truth, and 30 days later we get an errata sheet in the office swearing that everything he testified to, and he had a chance to come in and say, "Hey, looking back on it, I was," whatever he could have said. And so we had the errata sheet that we thought was just as powerful as the testimony, because it gave them 30 days to fix it, and they chose not to fix it.
Right, and I mean, I think it later came out after the congressional investigation into this that when it came to ignition switch change documents, his name was on there like 184 times or something like that.
And some other GM engineers. They've always tried to say it was DiGiorgio was this rogue employee, but there were other employees that knew about it as well, higher level employees, but that was their story, and they continue to stick to it.
Yeah, so, I wanted you to talk us through a little bit, because this was very unusual from your case. So at some point, you had gotten the case to a point where GM wanted to settle the case with you, and they actually did settle the case with you. And then you learned more information after that. So talk through the settlement and then what you learned after that.
They had actually approached us before they produced any of these documents. Lance, we need to sit down and mediate. We need to settle this case. And I sat down with Ken and Beth, and this is where they are the true heroes in this litigation, because I sat down with them and said, they want to settle. I think they'll pay you a fair amount of money. We still had Thornton Chevrolet in the case for reasons we won't talk about. They had a lot of culpability as well for what they had done. And I said, but I don't think we should, because I think there's more out there. And we had that conversation at least 3 or 4 times as these documents continued to be produced. They want to settle, but let's not settle. And every time Ken and Beth would say, we're going to do what you want us to do, or what you recommend we do. And that is why we have all these documents. Because if we'd agreed to a mediation before all this stuff had come out, and we'd have settled for the amount we originally settled for, which is what happened, we subsequently discovered they settled with really good trial lawyers cases before, because a lot of these cases, if you understand, the airbag non-deploy cases, someone's at fault in the crash, and a lot of times it's the person who's hurt. So if they come in and offer you a fair amount of money, a normal lawyer in a normal case is going to say, well, gosh, they offered a substantial amount of money in the very first case, Amber Rose, a young girl who died, around, I think, equal to the cap in the state. And they were able to basically, that's how they got away with it. And it's not lawyers not doing their job. Lawyers are doing their job and representing clients in each individual case, and those cases all settled. We just happen to have remarkable clients who just said, no, we're not going to settle until we discover the truth. And that's where we got ultimately to the settlement, because we thought we had run the course that we could with GM, and we still had the issue with Thornton. And to make a long story short, Thornton knew about the technical service bulletin. Thornton knew about the keychain, the keychains they should have made, and Thornton didn't do it for Brooke the day before the crash. So GM's position was, listen, we had a bulletin. Our dealer just didn't find it and didn't put this, and Charlie Miller had to admit if the key had been fixed, it's not the switch, it's the key. We don't need to get into all the details. And so we had a big problem with Thornton. And that's, people say, why did you settle with GM? We thought, well, that was in the best interest of the clients at that point as far as the case getting ready to go to trial. And so that's ultimately what happened. And then the case settled in the fall of 2013, and there were a couple of months passed, and we were looking into filing a class action lawsuit, but I am not a class action lawyer, so I don't know much about that. And then it was funny, my father called me at the beginning of February of 2014 and said, you're in the paper. I said, what? He's with the Waffle House up in Barrett Parkway that morning. He picked up the USA Today, and we were on the front page of the business section. And he says, and he was fine. I'm proud of you, son, and all that. But so I went and looked at it, I read it, and I thought, wow, but then I thought, wait a minute, they're recalling like 700,000 cars. There's like millions of these cars with this switch. And what GM had done is just issued this little one-page recall, it's sort of innocuous, well, we found there's an issue, and we're going to recall it, and no harm here. And that's how it turned out. And we, again, Sean Kane, I called Sean and said, what do we do about this? There's millions more of these cars. And Sean said, let's file a timeliness query saying even on these 700,000, they had a duty under federal law to notify the government within 5 days, and it's been a decade they've known about this. And we also need to tell them there's millions of more cars involved. And so we filed this timeliness query, and I think a couple of days later, GM expanded the recall. GM's point was we didn't expand it because of any lawyer letter or anything like that. We realized based on our investigation we should have done this to start with. And then ultimately it blew up from there with all these recalls. And that's where at the congressional hearing, the document got out where DeGiorgio did make the change that they had fraudulently concealed from us. And then all this evidence of these other cases came out, and I sat down with Ken and Beth and said they committed fraud, and I said, I think there's still more out there. In particular, I said the in-house lawyers, GM's General Counsel's office, was communicating with their outside counsel over these last 10 years on these individual cases. We need to get those documents to see whether there was some sort of crime fraud that was going on. And I remember sitting down with Ken and Beth in the office with them saying, and they were not people of great means. I mean, they were middle-class folks trying to pay their bills every month. And I sat down with them in the office and said, Ken and Beth, I think we should offer to rescind the agreement and give the money back because we need to find out what happened, and I don't think anyone else is going to be able to. I said we can be back in front of Judge Tanksley because Thornton was still in the case. And I said, I know this is going to take some time. I know it's going to, and they basically, we talked for about 5 minutes, and they said, we're in. And so I sent a letter the next day to GM. We got a letter from, this is now Kirkland & Ellis back saying, pound sand, we have a settlement, and it kind of went from there.
Right, and so you ultimately were able to get GM back into the case and able to really get to the bottom of all the documents that were out there about GM.
Yeah, so we got, Beasley Allen got involved, Jerry and Greg and Cole and others got involved, and we decided to work together on the second case. And yeah, it was the most encouraging and discouraging time of my practice. It was encouraging because ultimately GM had to produce all of those internal documents, those which would ordinarily be considered privileged, and it was remarkable what these lawyers were telling GM back as early as the mid-2000s about the problems with these cases and why they should settle them. But there was all this thing, we should settle, and then we should move on. And there was never, we should settle and then we should get to the root of the problem. I mean, and even lawyers, in-house lawyers, have a responsibility. But it was always, let's just kick this can down the road, get this plaintiff paid off, and just move forward. And that's when I realized how remarkable what Ken and Beth did, because they easily could have been in that situation. And I can tell you, I would not be here today. This would never have been uncovered in all likelihood, because these vehicles were getting older, and this was they had been able to basically cover it up for almost a decade at that point. And so what Ken and Beth did was pretty remarkable. And they ended up. The problem was we got sucked into this MDL, and I know y'all have heard about the goods and the bad and ugly about MDLs, but you know, we essentially lost control of the case to a certain extent because of what was going on in the MDL. And I sat down with Ken and Beth after all the documents had been produced and everything had been done, and we got a trial date set after the first MDL trial, and it was just I don't need to get into all that other than it was just a mess. Right. And I said, Ken and Beth, you've done your job. There's nothing more you can do. And they asked me, what would a jury do? And I said, well, and I was pretty candid with them, and y'all know this. I said, on a wrongful death case, they can award whatever they want to award, but there's generally a range. And I said, punitive damages under Georgia law, they can award $100, $200 million. I said, the problem is GM has paid all these fines, issued these recalls, engaged in this compensation plan, and all that evidence is probably going to come in. And I said, the jury may get mad at GM, but you know, they can also look at GM and say, well, they paid their penance, so to speak. And I said, in addition to that, we get a big punitive damage verdict. Let me just tell you practically, the state's going to take 3/4 of it. And then the other quarter is going to be taxable to you. I said, let's just talk brass tacks. What's going to happen if this all happens? And I said, not to mention the fact we're going to be 5 years down the road. And it wasn't about the money to them. It really was not. It was more about the having it over with. And I'll make this point. I think it's important. We never talked about money in this case until the day before the first mediation. They didn't care. They really did. Their focus was on a lot more other than that. And I'll let you hear a lot of clients say that, but they really were truly like that. And at the end of the day, though, I had to advise them, and I remember telling them, I think we should settle the case, or we should try to settle the case. And you could see the relief in Beth. Beth in particular. We had press conference after press conference. They did yeoman's work. They went up to Congress. They did everything they needed to do to get the word out, but their job was done. And I told them that. And I didn't think they would pay. And I called Ken Feinberg, who was the compensation. He actually called us wanting to settle the case. And long story short, worked with Mr. Feinberg and got the case settled.
Well, I think one of the ways that the money did matter early on, and you touched on this, was that this was a perfect example of how damages caps and tort reform can hurt public safety, because there were, as you mentioned, other good firms in good states that had caps on damages, and so it just wasn't financially viable for them to fight the fight in discovery and to spend the money to find out what was really happening.
True story, Rademacher, the case I told in Wisconsin, the families went to one of the top product liability lawyers in Wisconsin. One of the girls' families did. And the lawyer told them, first of all, you know, there was fault on the driver, and they had caps in Wisconsin, and this lawyer said it's just not worth pursuing. You think about that. I mean, if that case, without tort reform, that case would have been pursued. And I have no doubt a good lawyer like that would have a good opportunity to uncover that. And in that respect, Brooke would be alive today if it was uncovered before 2010. So, and I made this point to a number of people, is, you know, tort reform is not only injurious to the individual who's suffering in a particular case, it's injurious to our society, because it prevents lawsuits, meritorious lawsuits, from being filed. And tort reform prevented that Rademacher case from being filed. And if it had been filed, who knows how many lives would have been saved. And you turn around and say, well, yeah, but the government's supposed to step in and fix it. We all know how that worked in this case. So the civil justice, and I know I'm preaching to the choir here, but I think we can't say this enough to the public. The civil justice system is the most critical component for accountability, and it's the free market. It's saying, hey, you sold this product, you made a profit on this product, but our system of government says if you sell a defective product, there's accountability, but that occurs in a court of law in front of a jury. And the government is incompetent for the most part to deal with that. We've seen that since the Pinot back in the 70s. It's always trial lawyers who are discovering these defects, and the government comes in after the fact and has to have some excuse as to why they didn't uncover it. And, you know, and I say this, I mean, after GM, people were saying, well, is this ever going to happen again? And then we had Takata with the airbags. It's going on right now. There are cases out there now, I'm sure, where we're going to find that manufacturers at this moment are doing things that are harming consumers, and only trial lawyers and the clients that they represent who are courageous enough to pursue these cases will get to the bottom of it. That's my soapbox. I apologize.
No, and I think it's definitely a soapbox that we need to talk about on this, and everybody in this room certainly knows about it. And I should have said on the podcast that we're with the Georgia trial lawyers right now. But I wanted to go back to the Rademacher case for a second because I didn't realize this, but you'd said that a police officer had actually figured out what happened in that case in 2007.
Correct.
And then because of the caps that Wisconsin had on wrongful death cases, basically the law firm wouldn't really pursue it, or no law firm would. But I mean, that really just does bring home, how putting a arbitrary cap on what somebody's life is worth, really cost the rest of the U.S. and ended up with millions of cars on the road that shouldn't have been on the road.
Yeah, exactly. No, that's the result of tort reform, is wrongdoers are not held accountable. And that's what it is.
I wanted to talk something, you've mentioned it a little bit here, but I wanted to talk more about it. The regulatory agency for auto manufacturers is the National Highway Transportation or Traffic Safety Administration, and they have the Federal Motor Vehicle Safety Standards, and anybody who's done cases against auto manufacturers knows that the very first thing that they say when they go in front of a jury is that we met or exceeded all Federal Motor Vehicle Safety Standards. So this is a great car. Talk about the shortcomings of NHTSA, and I'm not saying just them, but I mean their agency isn't able to deal with problems like this and how they miss problems like this, and talk a little bit about NHTSA and.
Well, as we know, this federal motor vehicle safety standards are minimum standards, and car companies recognize they should design above those standards, but when they go in front of a jury, they have this amnesia about their due care requirements, and they say, well, we met the minimum standards, so if the federal government has decided this vehicle is not defective and not recalled this vehicle, how can you, as a jury, decide that it's defective? And that's the sum of the argument. There's motions in limine that can handle that to a certain extent, but that's the sum of the argument. And let me tell you how it came up in the Melton case. Ken and Beth, rightfully, just as ordinary consumers, said during the middle of this litigation when this ignition switch issue came out, can we notify the government about this? And I said, well, let me tell you my experience about that with other lawyers. And I said, when we've notified the government in the past about concerns we've had about vehicles, the government sometimes has come out and said, well, we're not going to find a defect here. And then the manufacturer waves that around and says, well, there's no defect. And so I've said my experience, and it was in a couple of actual cases, was it's harmful to contact the government because they're likely going to hurt your case because of the NHTSA revolving door we all know about, and people don't like to be too critical in NHTSA. I'm real critical in NHTSA. I mean, people that go to the agency, oftentimes the higher level political appointees, they end up leaving and become lobbyists for the manufacturers, and it's a vicious cycle. And so the government is not either able at this, both institutionally as well as just because the personalities involved, able to properly regulate these auto manufacturers. And I told Ken and Beth, we should not go to the government in this case. And they chose not to, and they were concerned about that, but I said I think it'll be harmful, and ultimately I think it would have been, because these vehicles were a little older, and just as in 2008 and 2009 when GM met with NHTSA and NHTSA didn't do anything, my concern was they were going to do the same. And I think that we haven't seen much difference since then. The government says it's changing, and GM says it's changed, But I can tell you in a couple cases I have with GM, as I've said before, they're still the same old GM.
One thing I was just wondering out of curiosity in this case is when Brooke was involved in the collision, there was another vehicle, the Ford Focus, and I think that person was represented by a lawyer, and they may have actually pursued a claim against Miss Melton. I don't know, but did that driver ever pursue anything against General Motors?
They did not. They weren't hurt that significantly, and that was never pursued. That's again one of the reasons they came in, though, Ken and Beth. There was some concern that the driver was going to bring a claim because Brooke had come in the lane. And they came to me through an insurance adjuster that I had settled a case with recently. The adjuster recommended us, so that's another practice point, or be nice as you can.
Sometimes it's hard to remember.
Yeah, exactly.
Well, that's tremendous work. Well, Lance, we've talked for about an hour here, and I just wanted to make sure, is there anything else that you want to make sure that our listeners know about the Melton versus General Motors case that we haven't talked about already?
No, I appreciate you giving me the time to speak.
Well, and like I said, this has just been tremendous work, and I know you said it's just the same thing you do every day, but I mean, this case really stands out, and I will say that not only, for you and your team that worked on this, but really having clients like Ken and Beth Melton who are willing to stick with it, to see it through, and to make sure that that their daughter is remembered, and that the car company is held accountable, is so important. And so, but it's really just fantastic work, and we wish nothing but the best for the Melton family.
I'll let them know. Thank you.
Well, and I wanted to remind everybody on the podcast that we've been talking to Lance Cooper, senior partner at the Cooper firm, and you can look up Lance at thecooperfirm.com. Thank you so much, Lance.
Thank you.
All right, and thank you, GTLA.
That was awesome. That wasn't too long.
No, you were great.
Thank you.